The employment relationship is contractual in nature, and like all contracts, terminations do occur. Some reasons require termination of the employer-employee relationship. Today on Law Express, we discuss termination of employment for ill treatment and sexual harassment. I have two private legal practitioners with me as usual in the studio to do justice to the topic. But before you meet them, we'll go for a quick commercial break, and when we come back, you get to meet them and then we get into the conversation. My name is Noella Seidu. This is Law Express.
No victim of gender-based violence should be silent. Every human deserves dignity and respect. If your health, dignity, and security is undermined, you must seek assistance. Call the Orange Support Center for assistance on toll-free number 0800 111 222. This message is by the kind courtesy of the United Nations Population Fund, UNFPA.
My mother passed on to me an age-old moisturizing secret handed down from generation to generation. Shea butter has been and still remains the ultimate and trusted natural product for the skin. It is safe for all, including newborns. I use Violon Shea butter products for my hair and skin and for all my children right from birth. Violon Shea butter is an amazing diaper cream. I love my family. That is why I trust only Violon Shea butter products for our skincare needs.
Violon Shea butter. Feed your skin right.
Bobby Banson. Bobby is a private legal practitioner. He enjoys swimming and playing football. Samuel is a private legal practitioner. He likes to go on law walks, to watch movies, and he's also a writer. His latest work is featured in the Writers Project of Ghana's latest collection, and it is titled Resilience. Noella Seidu. Noella is a private legal practitioner and a consistent member of our three-lawyer panel on the show. She plays a dual role as the host of the show and likes to play tennis and read.
Every kind of relationship between parties in the context of the law must be governed by some form of agreement. Because if you don't know what your rights are, you will not know what your obligations are. They go both ways. Yeah. And it's no different in an employment relationship. It's commonly said that employment is not a slavery. It's not slavery. And so it's not like we've moved away from the term master-servant to employer-employee to show that indeed it's a relationship that is governed by rules, that is governed by rights, that is governed by obligations, so that the contractual relationship between the employer and the employee is such that there are some basic terms that are required by law to be in that form of arrangement. The law has now made it very clear that once somebody starts working for another, within a period of 2 months, there must be an agreement. Yeah. It's been developed in such a way that the agreement need not be, 5 pages, 3 pages, or even 1 page that somebody will write wherefore, whereas, the normal legalese terms. Yeah. But the agreement can be even an email correspondence that I will require your services to do A, B, C, D. This is how much you earn at the end of the month. These are the hours of working. These are your leave days. These are your other rights, your other benefits. Yeah. You respond, yes, I agree. That is a contract.
Bobby, yes. You are already going to the main substance of the employer-employee relationship. That is a topic on its own. Okay. We're going to call you back, certainly, to come and have that conversation. Sure. because we have limited time on the show, if we're not careful, we might get carried away and we'll never come to the actual reason for today, which is termination of this employment relationship you have just summarized.
All right, so I think Bobby summed up the argument very nicely.
Yeah.
And I'll build up from where he ended. So the starting point for employment contract, employment relationship is that it's not a contract of slavery. These are two independent people. One has the money, the other has the skill. They merge together for the purpose of a business. Or the opportunity, yes. So ordinarily, it should be possible for each and every one of them to decide when to end the relationship. And the relationship could be ended for a variety of reasons. It could be on health grounds. It could be on grounds of competency. It could be on grounds of, unfortunately, I don't want to see
maybe
you anymore.
better opportunities.
Better opportunities. But I think our discussion today is narrow. So we'll be focusing on the question of ill treatment and sexual harassment.
Yeah. So now I'm sure we would have to break down further what, if you say ill treatment in that workspace, what it entails. We will probably have to look at it from the perspective of ill treatment being meted out to the employee by the employer or the system of employment.
The thing about ill treatment, I mean, let me take the two concepts and before I pass it on to Bobby. So ill treatment, sexual harassment. I think sexual harassment is a bit more specific, which refers to a specific kind of conduct. But then and again, the Labor Act recognizes that when you are dealing with human beings, it is possible that they may be acting within the law, or they may find ingenious ways of acting outside of the law without necessarily breaking the law.
Yeah.
And that's why the concept of ill treatment also comes in. So even though sexual harassment is very specific, ill treatment is broad enough and covers a wide variety of conducts which may not be sexual in nature, but may have the effect of hindering and undermining a person's confidence, ability to work, ability to focus and earn more income, and also dignity and well-being, physical, mental.
Yeah.
So ill treatment is a very broad concept. It cuts across so many conducts. But ultimately, these are guarantees for the employee to make sure that the employee works in a safe environment, to make sure the employee has some minimum standards in terms of what he or she is to expect within the workplace. And before I end, I would like to say that the concept of ill treatment and sexual harassment goes back to a fundamental obligation of the employer, which is to look out for the interest of the worker.
And well-being.
And well-being of the worker.
Great.
Whilst Samuel was talking, it's crossed my mind that the relationship between ill treatment and some of the general provisions in the Constitution ensuring the fundamental, you use the word dignity of the employee. And sometimes you would see borderline situations where the employer would say, well, I have not breached, show me the provision of the Labor Act that I have breached. But you sit back and say, no, you have not necessarily breached a provision. But if we put your conduct A, B, C, D, E together, generally it will affect the well-being. He might use the word mental well-being of the employee. And these days where mental health situations are
getting more attention.
It could be a perfect, for example, in some countries we have read that you cannot call an employee beyond at a certain time of the day.
Yeah.
Is it something that it's not illegal for your boss to text you at 9 p.m.? You may decide to open it or not open it, but the fact that he has texted you means that he's expecting some feedback.
Yeah.
Are we getting to a situation where those may constitute some form of, if your employer decides not to treat you well, for lack of a better word, and say that, well, when I send you text after work hours, you do not respond. Those are actions or omissions of the employer where when they stand on their own may not be seen as ill treatment, but when they are put together, then you see that there's a concerted effort that in the long run, and it's very subjective, I think so. Yeah. It should be a very subjective test because what may affect me, may not necessarily affect another worker. And so the employer should take the situation and the position of each employee in context or before taking any
But there
such
should be a
any
minimum
such step.
standard regardless. The fact that the person is not offended or the person has a higher pain threshold doesn't mean that it's not ill treatment. I think that, yes, beyond the context and beyond the kind of job perhaps you do, because if maybe you are a nurse and you are required to be on call 24/7, even when you are off to save lives, then perhaps, and that's what comes to your context,
Yes,
the point of
exactly,
context.
exactly.
But where perhaps it's in the office and you think that because employee A is okay if you probably push her and she doesn't complain about it, it's an employee B does that,
also
then
take that
you
same-
should be
yeah.
able to pick and choose your victim. You know, there should be like the basic standard for you to treat every human being with some respect. And it brings us back to, what is the definition of ill treatment?
Okay, so let me take the sexual harassment first, then I tie it
Yeah,
in
because
with,
it's pretty straightforward here.
I tie it in with the ill treatment. Now, what the Labor Act simply says about sexual harassment is that, number one, it is any unwelcomed, offensive, or inopportunate sexual advance that is either made by a superior or a co-worker. Now, so the key words basically are unwelcome, offensive, importunate sexual advance. Now, that without more tells you one thing, and it actually came up a lot during this Me Too thing that actually came up, and there were lots of workplace discussions and reflections as to conduct at the workplace. One thing that came up, especially in the public commentary, was some people were saying, oh, but this conduct, oh, but this, oh, but this.
Downplaying it.
But once we are referring to sexual harassment, we are referring to a very personal, a very subjective thing. And the truth is that sexual harassment, whether a conduct amounts to a sexual harassment or not, ultimately is also a function of a relationship. So the same statement made between A and B may pass as a friendly statement, but the same statement made between...
Because of the background.
Because of the background, the
relationship
context.
Yeah.
And then I refer to what Bobby said, the subjectivity of what we refer to as the sexual harassment. It's a very subjective concept. It is personal. It attaches to the person, and the person is left to make a decision as to whether the conduct involved is unwelcome, the conduct involved is offensive, or the conduct involved is really just bothersome.
So if there is some act that any third party who sees that would see it to be sexual harassment, but the victim is comfortable and doesn't complain about it, are we supposed to allow it just because of the fact that it is a personal thing?
Then the person doesn't become a victim.
Yes.
Because if you, to repeat the words that are in the act, unwelcome, the unwelcome by who?
The
By
person is just
who,
neutral, perhaps. The person, you see, sometimes, I mean, the struggle is real for many, especially women, because most of these corporate spaces are controlled and dominated by men. Now, the man is influential. He's the CEO of the organization. You badly need this job to keep body and soul together. You are not complaining because you don't want to be, you don't want
on the streets.
on the streets. So, but that doesn't mean you are welcoming it as well. Everybody sees that you're uncomfortable. You don't want it. But for the very reason that you haven't come out to complain officially, make it a less offense.
I think that I have advised in very recent times, especially with respect to sexual harassment, that companies should have a sexual harassment policy.
Yeah.
And so that it's not as if that, okay, the Labor Act has provided these words, any conduct. Companies should be at pains to be able to list certain specific conducts that are prohibited within the workspace. So that whether you are the CEO or you are the HR, or you are the doorman, or you are the driver, you know, for instance, you cannot look at a female employee and then tell him, oh, I like your dress, it's brought out your curves. Then it takes away the subjectivity to an issue of corporate culture. So that to buttress what you are saying, people who may not be able to come out to speak about it because they don't want it to be like, oh, you know, a local, oh, you are some way, but I thought this was just a joke. Oh, are you not a woman? Or, oh, are you not a man? They may not have the voice to speak, but if the corporate culture prohibits these things, then if somebody goes ahead to say or, you know, exhibit these conduct, then the person knows that what you are saying, it doesn't depend on whether the recipient likes it or not.
Yeah.
This, our company, we don't like this. So the person need not be the victim. It is the company that becomes the victim. Because then your conduct is not in breach of the rights of the employee, but it's in breach of corporate culture and company policy. So I think that it's about time that we elevate it from, I mean, flowing from what you said, from being a subjective thing to being a company policy and corporate culture.
When you look at the initiation of this kind of termination, it appears that from the wording of the Act, it is something that is initiated by the worker. I don't see much about that from the employer. But then we know there could be an employer and employer sexual harassment or ill treatment. Shouldn't the entity or the company step in to probably protect the victim and initiate termination?
Okay, so there's a context to this.
Yeah.
And the context basically is that at the workplace, there's generally unequal power relations. So the employer is powerful. The employee, to choose your own words, has to decide whether to jump up on the street and you know, be left with nothing. So that distinction between the employer and the employee, even though we deceptively say that, oh, now there's no master-servant relationship, they are all equal in the eyes of the law. I mean, theoretically, it is true and it's correct. But in the terms of the practice, a lot of people, especially employees, would have very little option in terms of staying in a workplace which is abusive. So the structuring of the Act deals with a power problem. And the power problem here is that it gives you the advantage, it gives the employee the advantage to then decide, you know what, the law says that I can jump out of the business or the company with or without notice and still sue my employer.
So you're not jumping out for nothing?
No.
You still will get compensation. Before we get to the issue of compensation, I would like to introduce another dynamic, because we have painted a picture that in most cases is the employer who is more powerful. But there are times that some employees, for some reason, have more power in an entity. But before we jump into that further, we'll go for a quick commercial break. When we return, we pick it from there.
My mother passed on to me an age-old moisturizing secret handed down from generation to generation. Shea butter has been and still remains the ultimate and trusted natural product for the skin. It is safe for all, including newborns. I use Violon Shea butter products for my hair and skin, and for all my children right from birth. Violon Shea butter is an amazing diaper cream. I love my family. That is why I trust only Violon Shea butter products for our skincare needs.
Violon Shea Butter. Feed your skin right.
Thanks for staying with us. So, Samuel, assuming it works this way, where the employee has a special skill, nobody else has that skill in that entire place. He or she is the engine of the organization. The boss is just the investor, And without this specialized craftsman or woman, the company will fall. Here, the power dynamics naturally will change, because as an employer with all that money, you're still powerless, because if you play, the company goes down. Here, can't there be a situation where this employee now ill-treats the boss and everybody else in the company?
Well, I mean, so that's possible. You can't rule that out. But at the very least, the boss has options.
Yeah.
When you compare that to the employee would typically, you're looking at your bank account and your finances and the bottom line, and
the hassle is real.
The hassle is real, and it's the kind of thing that you need to live with. The employer does not need to live with it. I mean, you probably tolerate the person for a while.
To this whole venture.
Yeah.
Well, I mean, you tolerate the person for a while, but you're on the market looking for alternatives. So that is not so much of a big problem within the context of the Act. I think what the Act's main focus on is protection of the employees.
So it's about the vulnerable side in this arrangement.
Absolutely.
I also think that we should mention that it can also involve an employee and an employee.
Yes.
Yeah.
So that the employer can terminate an arrangement with an employee because that employee has sexually harassed another employee. In my professional life, I've dealt with a situation where an employee was dismissed because he continually sexually harassed other employees.
Yeah.
And so I think there are about 3 of them who came forward and wrote, first it was anonymous, the first, the second, the third person wrote her name and said, these other 2 people are the anonymous ones. And so a committee was set up, a committee of inquiry was set up, it was investigated, it was realized that this is what he actually does. And so the employment was terminated. And so the employer also has that responsibility to ensure that if it is between employee, once it comes to its notice, he has a responsibility to see to it.
Let me make this a brief point about, because it's something that comes up fairly often, about the frequency of the conduct.
Okay.
In other words, how many times
Yeah.
must one do something in order for it to qualify as sexual harassment? And from the Act, what that we see is that it's an unwelcome conduct. It's an offensive conduct. So how offensive must it be? How unwelcome must it be? Would a one-off statement qualify as sexual harassment? Would a one-off touching qualify? Must it be frequent? Must it be consistent?
Must it be intentional?
Must it be intentional?
Because that has come up quite often, whether, that was what I intended to do. So is it a strict liability offense?
Absolutely.
Yeah.
So all of these things, and there aren't easy answers to it, but I think the key thing is it's about the gravity of the conduct. I mean, if it's a silly statement somebody makes, you could simply tell the person, you know what, I don't like this statement. I don't appreciate that statement. At that point, you've marked it out as an unwelcome conduct.
Okay.
It's clear. But if the person touches you at a place which obviously the person has no business doing so, then once again, like I said, it's a question of degree. And that clearly would suffice as sexual harassment. So it is important to put it out there that a one-off conduct may suffice as sexual harassment. The thing about this sexual harassment thing also is that it can get very murky under certain circumstances, especially when the people were previously in a relationship at the workplace, especially if the company's rules, because some companies expressly prohibit relationships at the workplace. But in instances where the workplace rules does not prohibit such conduct, and the people were previously in a relationship, then something happens, they break up, next thing we hear, one is complaining about sexual harassment. I mean, this naturally is.
But it's possible.
No, I mean, it's possible.
It still is possible.
It's
Perhaps
possible.
Post breakup, somebody could misconducted himself at that point. for as long as it was not welcomed.
Yeah.
You harassed
You
him or
harassed.
her, and especially if it's in the work environment,
Asking for comebacks.
yeah,
During
harassed,
working hours.
you know, unwelcome soliciting for a renewal of the
I think
contract.
it's a very fluid thing, and
Yeah.
for me, and I've discussed this with Samuel before, that law develops if there is noted practice, so there are court decisions, there are rulings. I think we roamed through the law reports and we found only one case hidden somewhere.
Yeah.
Which, because of the parties involved, you would not even want to
Yeah.
mention here.
Yeah.
Hidden somewhere on sexual harassment. And it's because of the culture, people don't want to say it.
Yeah.
But if we don't have these in the public space in such a way that we know, okay, this is how the law is being interpreted. For example, as you speak now, we do not have a definite judicial pronouncement on some of these things in the
Yes.
Act.
Yeah.
Yeah.
So we do not have clear guidelines. Now, I asked someone some time ago this question. A work closes officially at 5. The work provides a bus that transports workers, let's say, from Spintex to Accra Mall. So 5 o'clock, all workers that live on the N1 join the work bus from Spintex to Accra Mall. Then there's this particular guy, or it's always the guys, let me turn it around. There's this particular lady who targets this guy, always make sure that where the guy goes to sit by the guy. Then as the bus starts, the journey starts. You're a very fine guy. Whenever I see you, then something they do me. And blah, blah, blah. And the guy consults a lawyer, and the lawyer says, but it's actually out of working hours. Technically. But you
But
are
you're
still
in the work bus.
In the work bus.
And it's still the work
And
that
then-
has put you in that space.
Reports to the employer. Then the employer says, well, I'm not responsible for
It's not
whatever
compulsory
happens.
to sit in the
If you
bus.
want, report it to the police for criminal.
Yeah, prosecution.
Prosecution.
Which man would have the
Courage.
courage?
They'll
But-
call you weak.
so
That's our society.
it's a whole, so it makes it like Sami said, it's murky. It's not something that they are clear cut. The law has provided what constitutes, but it's very general.
You know, it's a very interesting dynamic you're bringing into the conversation. We have to explore it some more. But we sampled people's opinion on the streets on this
Okay.
topic. Let's take a listen and see where their minds are at, and then we could respond to that and then continue with our conversation.
Absolutely.
The issue of sexual harassment and whether or not an employers actually address sexual issues in the office. I think it's more about the courage of the workers or the employees to even report such cases. Speaking as a student, I was in such a situation. A lecturer was trying to do something like that, but people told me that I can't report the case because if you report the case, it may happen that they'll give you an E, you meet the lecturer will hate you for life, and they will not let you graduate and all those things. Those are the issues, and definitely you'll be scared to bring out those reports. You go and report. What if the person you are coming to report will also request the same thing from you? And so there's that issue. But in my case, I got fortunate and I reported to the lady who took up the issue, and my case was resolved, and I got an A in that particular course. But the issue today is that ladies who get harassed in the office are afraid to bring the issues to management. And so it is not about management not making time for issues of sexual harassment, but that people who are being harassed in the office find it difficult to come out and say it, and even to think that sometimes when you come out, they may not believe you, that because some of these employers have a reputation, and that because of that reputation, if you come out saying that this particular person harassed me in the office, people won't believe you, and it might go against you, and you might lose your job.
So on the issue of sexual harassment, I think it's when someone makes sexual advances towards you without your permission. And I think as young girls especially, we should speak up anytime someone even tries to get sexual with us. the only advice I can give my fellow ladies is to always make sure they are not too close to these men, especially in enclosed areas, and always be in open places so that the tension doesn't get high and all. Young ladies dress well, because you don't want to be wearing provocative dresses and all to attract men.
The videos raise very interesting questions, which would definitely, I mean, we may not have the full answers to, but we hope to assist in fleshing out what the issues would be. I think the critical one for me is the question about believability of, the victim. Is it easy for the victim to be believed? So typically, in the absence of WhatsApp messages or
some other evidence,
tangible evidence of some statements and communication being made, it's really just between the two parties. And unfortunately, it may be difficult to prove and meet the kind of standards that the court will require of you.
You and I went. One thing that caught my attention from the video is the misconception that it's a defense to say you were provoked. I mean, it's no defense,
and there
guys.
was somebody saying that the girls should dress well and all of
guys,
that.
let's get it very clear.
As if men always dress okay.
It's no defense
badly,
for you to say that you were tempted by the lady. The lady called for it, or you thought that she was calling for it. It's no defense. I mean, yes, I get the lady you interview to say, well, as an advice to women, don't wear provocative dresses. But as the advice to men, don't think that it's a defense if your employment is terminated for sexual harassment to say, well, she wore a very short dress to work. It's not your duty to interpret what she wore, or what she says, or how she presents herself.
I mean, how come everybody else didn't interpret it to mean
except you? So it's no defense. It's like we've stated, it's subjective. The person must deem your actions as unwelcome, as offensive. And so you cannot justify it and say, I thought he wanted it, or I thought she wanted it.
When you look at this harassment situation, where a lady is harassed, for the very reason that there is no actual carnal knowledge, which becomes a very good evidence, people assume that you should be flattered that the boss or some other colleague even finds you desirable. So where a woman complains about things like this, she's likely to be met with statements like, oh, you're being too sensitive, shouldn't you be flattered, you should just let things be. And that is another reason why we don't see a lot of these reports. Same with the men. I mean, can you imagine a man walks up to his boss to say that, look, this secretary here has been harassing me? Many people will laugh. Even his colleague men will laugh.
Yeah.
And everybody else would probably nickname him. And this is...
Sorry. No, I mean, it's a big problem, and it's cultural. I mean, we've got certain expectations and all. I mean, men are victims of domestic violence, but rarely on the record, as victims. So with the kind of, constitution and legal system that we've built for ourselves and all, there are certain expectations of us. And one of those expectations, which we mentioned earlier, is dignity. And it's personal. It attaches to the person, which ties in with one of the points that the interviewers raised about courage. Because in the midst of all of these things, you need courage to express yourself, to take it to the next level, even when everybody thinks it's all right. And we have this very interesting culture, I think both naturally and also at the workplace, where people agree it's a problem, but do not have the courage to confront it.
Or they see it as normal. They've become so used to seeing it, so rife.
Yes. And in the case where the employer is the one doing it, people see a dead end. And that's why companies need to take a bit more proactive role in holding themselves to account, holding key management personnel to account, and making sure that, you know, they lead from the top.
Yeah.
Because ultimately, this affects the morale of the workers, because it affects productivity, it affects the psychological well-being, and most importantly, in today's world, it affects your reputation. I don't think you even need an incident within your company to ask yourself how we are doing in this area or on this particular metric.
Yeah.
I think companies maybe every now and then should ask themselves, how are we doing?
But that is if there is a policy and direction in that
Absolutely.
regard.
Yeah.
Because the government, as the biggest employer, even doesn't have a clear-cut policy on sexual harassment, where there's a policy document that once you are engaged into the public service or civil service, there is this little guide for you to know what constitutes sexual harassment. I think more can be done in that regard. And once that is done in the space of the state's employment network, naturally private companies would have to follow.
I agree. I was actually just thinking that, okay, so beyond the termination,
Yes.
both ways, which if you want some rights, your only option seems to be go to court.
Yeah.
Do we have any avenue? And thinking about the role of government, we have Domestic Violence Act that deals with the outside employment scenarios.
Yeah.
And you have DOFSU that has been set up not only to provide, to also provide psychological support for victims of domestic violence. If it is in a public environment, like public employment space, you have SHRAJ, which may extend their jurisdiction, like the case we found, to those areas. Now, I asked myself, as on this panel, as we were sitting here, that, okay, is there any institution that people who work for private companies, can also go to say, okay, I don't want my name out there, but this is what, we have to leave it to private journalists to do a piece, cover their faces, and then
what happens
and
after?
then what happens? And so, as maybe the state or the Ministry of Employment should insist that every employer should have a whistleblower, regime for sexual harassment alone. There's whistleblower for corruption. There's whistleblower for every other thing, apart from things that will directly affect the psychological well-being, like Sami said, of the employee or the employer. And beyond that, they may take it to maybe a state, entity that would provide that kind of assistance and be able to investigate and come up with decisions. Because the reason why a lot of people are not courageous to report is that once you go to the police using the criminal regime, it's public. Once you go to court seeking redress, it's public, because in our legal system, unless you're an infant, your name must appear on the summons, the writ of summons. And then it becomes problematic, because a lot of people would not want that. And so they just keep quiet and take a walk. So maybe the state should look, like you rightly suggested, should take a step to provide a proper, not only legal, but perhaps a mental health regime to make sure that there's
even
some,
beyond that.
Beyond
we've not yet touched on compensation and that route, how you can get compensation beyond the termination. But then it's time for yet another commercial break. So we'll go, and then when we return, we have to discuss that.
Okay.
My mother passed on to me an age-old moisturizing secret handed down from generation to generation. Shea butter has been and still remains the ultimate and trusted natural product for the skin. It is safe for all, including newborns. I use Violon Shea butter products for my hair and skin, and for all my children right from birth. Violon Shea butter is an amazing diaper cream. I love my family. That is why I trust only Violon Shea Butter products for our skincare needs.
Violon Shea Butter. Feed your skin right.
No victim of gender-based violence should be silent. Every human deserves dignity and respect. If your health, dignity, and security is undermined, you must seek assistance. Call the Orange Support Center for assistance on toll-free number 0800 111 222. This message is by the kind courtesy of the United Nations Population Fund, UNFPA.
Before the break, we wanted to talk about compensation. So you are an employee. There's been an incidence of sexual harassment or ill treatment, and you have initiated the process of termination. Is that all for you? Can you just go home and now hustle till you find the next employer who is responsible enough to protect the environment within which you work?
I think that a victim should be entitled to some form of damages under tort.
Yeah.
I'm sure that beyond contracts, there should be some head of damages that may be awarded against an employer, whether the employer is the perpetuator or the employer provided an environment that will encourage the perpetuation of or the undertaking of such sexual harassment. Like we have said, unfortunately, we do not have any case law to support how the courts have gone about such. But if we want to take experience from other jurisdictions, we know there are institutions that have been slapped with heavy damages for not encouraging employees to report sexual harassment, for covering up sexual harassment that have been reported, and for not properly dealing with ones that have been, so that an employee would have a recourse, not against a fellow employee who engages in sexual harassment, but also extend it to the employer who provides an environment that is conducive for such things. And it's more easier if it's directly from the employee to the employer, suing the employer for it. So definitely the courts will look at some head of damages. Maybe it will affect the psychological well-being or general damages for breach of contract. But then this may become breach of actually a statute, a declaration that the employer has not provided a conducive environment. And how would the employee or how would the court treat these kind of damages? If the employee is able to, or the victim, let me use that way, is able to show that I have suffered mental trauma or things like that. Because listen, just like rape or defilement, sexual harassment has the same mental effect on victims. It's not necessarily that there was penetration. I hope I can say it on your set.
Yeah.
Okay, above 18 people.
Yeah.
It's not as if that there was, or it's not that the fact that there was no penetration means that it's less of a crime.
Yeah.
Because some women or some men have been sexually harassed so much so that it's taken away their self-confidence. They cannot even sit with the opposite sex and not think that, okay, why is he looking at me like that? Or why is she looking at me? There's some fear. And if you're able to provide medical evidence
and
of this, you should be entitled to some form of damages. So it's not enough to terminate and walk away. I think that we should take such perpetuators on and provide a legal system that would be able to award punitive damages to make it unattractive, not only to conduct or to engage in sexual harassment, but if you provide an environment as an employer that would encourage sexual harassment, you should be able to suffer some form of punitive damages.
We have some questions coming in on social media, so let's attempt to answer them.
My boss asked me out. Initially, I was interested, so I led him on. I later realized I made a mistake and started cutting him off. He has not had sex with me yet and has not forced me to do it with him, but he keeps pestering me, comes to my house at odd hours, begging and acting funny sometimes at the office. His attitude is affecting me emotionally. Does this fall under sexual harassment? And what can I do in the face of the law? Nanekia from Bokwase.
Well, it's an unfortunate situation. I mean, once he remains your boss, then it falls in the context of what we've been discussing. It's an unwelcome advance, importunate remarks or comments that should not be entertained. Purely on legalistic ground, you can terminate your employment contract based on this. You may take the next step of suing for damages for this emotional trauma you said you suffer because of his actions. But on a realistic front, you would have to be ready to go the full length. Sometimes people underestimate and think, oh, it is enough to just terminate, to just ask for money. But you should stand by it and not fold up once you stand. And you should be ready. I think that victims should know that they are not doing this for themselves.
Yeah.
They should know that, okay, if I'm taking this bullet or I'm biting this bullet, I'm doing it for all other victims of sexual harassment and should be encouraged to be able to come out there. So, madam, it's a she, right? The one who sent in this question.
Yeah.
It's a she. So you should be able to, definitely you must speak to somebody you trust first. It's also part of the healing process. And say,
find a lawyer.
Well, yes. Yeah. This
You
is
can
what
trust
I'm
lawyers.
going through. This is the step I want to take. And then once you start, do not end. And then go through it. We've discussed all the other avenues available or the rights, the remedies that you may explore as provided under the law. And we think this is a perfect situation where you can do so.
So I agree 100% with Bobby. And this particular question really reflects and brings out some of the complexities. Because when she says, I led him on. So for instance, if there are text messages, right? And, so they are exchanging messages, which is quite suggestive and all.
And consensual.
Then you get to the point where you are no longer interested in whatever is brewing between the two of you. So the question is, how did you communicate that? And if you elevate it and you go to court and he says that, you know what, it was consensual. This is his message to me. This was my response. So I think it's at all points in time, clarity in messaging is absolutely important. And the thing about sexual harassment is that you need to be constantly re-evaluating your relationships with the other person all the time.
Drawing the line.
So you don't have a license for life. You probably have a license for that moment to say whatever you want to say, and it's acceptable. But remember that you may say something today, it may be acceptable, but you probably say that tomorrow, and it may not be.
Yeah.
So it's about constantly evaluating your relationship with the people, and frankly, being respectful of people's private spaces and their wishes and their desires as well.
I think that I agree with what you've both said on this matter. But when it comes to the harder question of how she communicated that, assuming there is this hard evidence of your consent at the beginning, but then the day you decided you didn't want to be part of this, you did that in person, and it's not documented. Well, it's not in every case that all will be lost. Perhaps the court may read into your conduct subsequently, if at all, to see that, yes, this shows that you were not consenting, because you can actually even consent to some acts and midway decide to withdraw your consent. So if perhaps there's no text message or email to show that you withdrew your consent, or you had stopped leading him on and there was no leadership at that point, then clearly, I mean, you could bring in some circumstantial evidence to support your assertion. So all is not entirely lost in that regard.
My boss and I dated for 9 months. I later found out she was married and I opted out. My boss has been putting too much pressure on me to come back to her, which I refused. These days, she gives me a lot of work and I almost every day leave the office after 10 p.m. I know it's deliberate to frustrate me to give in. She has recently threatened to transfer me to a rural branch. She sometimes squeezes my buttocks deliberately and she makes it look like it's a joke. This is really stressing me. I know she is doing all this just to make me give in to her. What can I do? Ken Fomusu.
Well, it's sorry for you, young man, if I may call you like that. You know, it falls under what we discussed earlier as a general. So yours fall under two instances where there's the pure sexual harassment that you would say that she's specifically asking you to come back to continue whatever you were doing and you don't want to.
Yeah.
And you have a second situation where she intentionally gives you work that will keep you in the office beyond working hours, and so that she can have access to you. And she is threatening to transfer you to another branch. So you see that sexual harassment is there, but as part of the component of the sexual harassment is what Samuel explained earlier as ill treatment.
Yeah.
So you are the receiving end of ill treatment because the ultimate aim of the perpetrator is to sexually harass you.
Yeah.
And so you have a double-edged sword in your instance. And then you can, of course, terminate the contract and then sue for damages for these
Madam is
whatever.
doing too much, clearly. I mean,
Pardon?
Madam is doing too much.
Well, whatever they used to do
reported.
as couples. You know, Batman has a song that who
is Batman? Samini, you mean?
Whatever he was doing that made her interested, she still wants it back. So that's the only avenue I think that he can explore.
But then he has the option to terminate the employment relationship.
That would be the first step. You know, it would be interesting if you do not terminate Barad and sue for damage. So you are not asking to walk out of the employment.
Because you don't have options, but you want the right thing done,
to be done.
And you want to be compensated.
So, exactly. So it's interesting. That option too is available, Sabi.
Yeah.
I don't think you must necessarily want to terminate the contract, except that the psychology, you cannot, fight with your boss and then still be in the same employment.
You haven't
cannot.
met
But
a
legally,
determined person before.
legally you can. So you need not necessarily terminate the employment. You can be in it, sue for declaration that her actions lead to ill treatment and constitute sexual harassment, and ask for damages for those, but not necessarily ask for termination if you want to.
So it's your decision.
In this context, the size of the organization would also matter. I mean, if it's a very small organization, then probably staying within the organization may not be tenable.
Yeah.
But if it's a huge organization with different teams and all, then you probably may be looking to, join some other team and, change leadership. So,
well, this has been an engaging conversation once again. Thank you so much, Mr. Samuel Alesu Doji. Thank you also, Mr. Bobby Banson, both private legal practitioners.
Thank you for having us.
Thank you for having us.
Very well. So my name is Noella Seydu, and it's been an interesting conversation on the termination of employment for ill treatment and sexual harassment. Of course, everybody still has rights. We have options, and it's important that we use our voices to speak out to be able to enforce these rights. And where you feel that in your employment contract or relationship, you are seeing incidents of ill treatment and harassment, you know what to do.